Hey, everybody. Good to see you again. Hope y'all are well. Um, we are back, and I'm here at the building so that my Wednesday, or I guess it's not your class that I have this issue, but on Wednesdays, for some reason, I'm always having trouble with my Wi-Fi at home. Never on Mondays, but on Wednesdays, or Tuesdays or Fridays, no problems. But Wednesdays, I'm having trouble. So I decided to come to law school, so you get to be in my office with me. So you're sort of in the building in some sort of virtual way. Um, one real quick housekeeping thing. Some of you guys did not take the quiz, and so I don't have a quiz score for you. I believe that I would like for you to still take the quiz. The point of the quiz is to make sure, for your sake more than mine, that you are sort of up to speed on what we are covering. And I think that in general, it is fairly straightforward. You know, should just be review. It's a quiz that is, as those of you who took it know, sort of backward looking, like what happened in these cases more or less, rather than application, which is what the practice exam and the real exam will actually be, you know, applying the concepts. But I do want to make sure that we are all on the same page. So I would like for you to still take the quiz. There will be a penalty for not taking it in the required time frame, but I'd like to get a sense of people's ability to grasp where we are, so that I know, so that if there are some red flags that I need to reach out to you, I would like to know. So if you haven't taken the quiz, do it. Questions on administrative stuff before we get back into O'Keefe? The plan for today is get through with O'Keefe, and then I'm going to open it for questions to the extent that we have time. So are there, before we get in, you know, those would be substantive questions. Are there administrative questions?
Yeah, Professor.
Yes.
In the syllabus, it says that during the first half of the semester, we should have small sections with you.
Yeah. Just pretend you didn't read that.
Okay, so
that's on me to organize, and so I still intend. I don't know if I intend to or not. I'd still like to do that because, but it's just the semester just kind of getting away from me.
Okay.
But yeah, don't worry about it in terms of the syllabus and course requirement standpoint. That's on me. Yeah, Davis.
My question is about the exam, like just about like the taking of it. I know you said set aside about 70 minutes, 75 minutes. Is that like once you open the quiz, it closes in 75 minutes for you to turn it in, or is that just like a recommended try to do it in this time so you can know what you're working with, like mentally?
So I'll be honest, I'm not going to make it so that it closes that quickly for a variety of reasons. The primary reason being that there are individuals who have accommodations for whom the exam timing will be different than for others, than the typical time that I give. And rather than for the practice exam going through the whole setting up of different times for different people, I'm going to leave it open for longer than 70 minutes. But, so if you are a student that has accommodations, kind of take that into account, that you will get an extended based on that period of time. But so it's more of a, to answer your question, Davis, it's more of a do it for your own benefit. I would actually encourage you guys to upload after, the time period, 70 minutes or so. And you need not stop working at that particular point, right? So you could upload at 70 minutes, or what I tell students sometimes to do, if you don't want to worry about uploading at a particular time, and I'll try to put this in the instructions, type out your exam answer, excuse me, type out your exam answer, and then when you get to 70 minutes, put a line on your exam, and if you're still working, then just keep working beyond that line. And that will send to me so that I'll grade, when I'm grading it, I will grade it up to that line. And so I won't like count your points beyond that line, but you'll still have the experience of sort of going beyond that. And I will read it beyond that line, but I will not sort of count the points. When I say count the points, this is not a grade. So really what I will do is provide you essentially how many points you got, and then a rough approximation of what the curve would have been if this was the exam. And so it won't be as precise as the final exam grade for a lot of reasons, but it will be an approximation. And y'all will take it through Twin. So what you'll do is not exactly like the quiz. And maybe you've done this in other classes, but there'll be a link on the left side that'll tell you, get your exam here, and you'll go and you'll click on a bunch of things the same way you would with the quiz, and then it'll give you a page, and then it'll let you download the exam from there, and then you're working, on your own document, and then you'll upload through Twin just like that as well. Maybe y'all have done that, some version of that through Legal Methods or something. Anything else?
Hey, Professor, I'm sorry, I didn't understand what you said just there about the drawing a line and the 70 minutes.
Yeah, so there's no real enforced time on this, on the practice exam. But if we're going to do it, if I'm going to grade it, and it's going to be like a real sort of reflection of everybody spending the same amount of time on it, that's what I would like. I would like everybody to spend roughly the same amount of time on it. I don't want somebody to spend 5 hours on it and therefore have the best exam answer, because that would skew everything. So what I was suggesting is, if you're in the middle of writing your exam, rather than artificially cutting yourself off at 70 minutes, just when the ding goes at 70 minutes, as you're typing your answer, you just, hit return, make a line, or write 70 minutes in bold so that I can see where 70 minutes happened to you. And if you want to keep working, then keep working beyond that line. And I'll read it, but in terms of counting points for the grade, I'll stop at that 70-minute line. Does that make sense?
Got it. Thanks. I appreciate it.
Mm-hmm. Anybody else? So the goal is really just to give you a sense of what it feels like to take an essay exam in this class, and do so in a way that is, risk-free. If you turn in, 10 words and spend 50 seconds on this, then you can check the box that you did it, but note that you will not get anything out of that experience. I'm trying to think if there's anything else. Oh, and I think I've said this already, but I'll make it available later today, but you guys can take it in any time between now and Monday. So set aside a time that works for you to take it. Okay? Good? All right, let's talk about O'Keefe again. And we're in this space because adverse possession of chattel is different and more complicated than adverse possession of real property. And what we know from this case is that we have two sort of wildly divergent versions of what happened. We have O'Keefe's version of what happened, which is that she had the paintings in her possession. They were stolen from her and in 1946, and she never reported anything until 1972, and then she discovered them in 1975. And so this is like a 29-year gap between when she discovered that they were gone and when she discovered where they were in order to claim them. And so a long period of time, most of that time in which she did virtually nothing except tell a friend or a couple of colleagues about it. Not even her husband, who was also essentially her manager. Okay, so that's her version of events. And so she thinks it begins with a theft, and should end with the paintings being returned to her. We have Snyder's version of events, which is really the Frank family's version of events, which is that in some way, some mysterious way that we aren't really sure about, the Frank family came into possession of these paintings in the 40s. Perhaps even they are claiming before O'Keefe thinks that they were stolen. Okay, so at some point in the 40s, they came to the Frank family. The Frank family had them for this whole period of time, displayed them a couple of times. It passed from the Frank parents to the Frank son, and then ultimately the Frank son sells it to Snyder. Okay, and so that's how Snyder is involved in this lawsuit. So we have these two competing factual stories about what happened. And as we closed on last Wednesday, we discussed the primary thing that we take out of this case is the discovery rule. The discovery rule being that for adverse possession to chattel, adverse possession to stuff, to personal property, how we determine when the clock starts is by answering the question, when should the true owner have known where the item was, all the elements of her cause of action? Because until that time, the true owner doesn't have an ability to sue. She's not actually sleeping on her rights until she knows how to reobtain her item. Okay? And so the discovery rule asks that question. When did the true owner know where it was? And when should the true owner have known? And it does a reversal of what our normal adverse possession does. Normally, when we're thinking about openness, we're looking not at what the true owner knew or didn't know, but we're rather looking at the behavior of the possessor. We're saying, is the adverse possessor possessing in such a way that puts the world on notice that they are claiming dominion over this land? Okay, so we've talked about openness in other contexts. Just to tie it back, in Manillo, we tweaked that once. And we said, well, actually, sometimes we actually need to shift the way of thinking about openness away from the behavior of the possessor and to the knowledge of the true owner. And so remember in Manillo, we had for small encroachments, openness isn't really a factor at all. The question is, the clock, or the rule is, the clock starts only once there is actual knowledge by the true owner of the small encroachment. Okay? Here with the discovery rule, same basic idea as in Manillo. What we're doing is we're saying, because of the nature of this adverse possession, just like in Manillo, the small encroachment, because of the nature of this adverse possession, we can't punish the owner for sleeping on their rights until they know that they need to not sleep on their rights or how they can not sleep on their rights. So in this instance, rather than saying actual knowledge, we actually have a slightly different standard, which is when did they either know or should they have known all the elements of their cause of action, which includes where the item is or who has the item. Okay, so if we're playing this out, what that means is, let's say we're dealing with the watch from the very beginning of class. Okay, and we kind of talked about adverse possession a little bit there, although we might not have used the words. But we talked about the idea that at some point, someone possessing something might earn title to it. That's, an adverse possession concept. Hopefully y'all can see that now. But we kind of tripped over how long it ought to be, etc. But so imagine what happened applying this new discovery rule in the watch context. In the watch context, what that would mean is when the loser of the watch, I forget their names, when the loser of the watch, until the loser of the watch should have known where the watch was and who to sue to get it back, Until that time, adverse possession clock doesn't start. So let's say that it's truly lost in the ground at the park, and that no matter how diligent the true owner was, they could not have found it, right? They could not have found it. And so the time in which they discovered who had the watch or where the watch was, the elements of their cause of action, would have been in the grocery store when they saw the finder of the watch wearing the watch, okay? And so according to the discovery rule, that moment is the moment that the adverse possession clock would have started. And so it would have been 5 years or 7 years or 10 years, whatever the statute is, from that moment that the loser of the watch would have had to reclaim it, okay? And we know that from the facts of the watch case, the loser of the watch reclaimed it immediately, right? They sued immediately, they demanded it back immediately. As soon as they knew the elements of their cause of action, they did not sleep on their rights. They exercised their rights, okay? And so to the extent that one might talk about adverse possession in the watch problem, with the facts that we had and the application now that we see the discovery rule, we can say that the finder of the watch would not have won based on adverse possession, okay? They might have won based on abandonment. There's other arguments that it's still unclear who's going to win this, who's going to win that case, but it is, I think, clear that if the discovery rule is applied, the finder of the watch on the first day of class could not have won through adverse possession, okay? So everybody good with that? Questions on that? We're good. So then the question becomes, when they remand the O'Keefe case and they are going to apply this discovery rule, what do they need to find out? What is the question going to be? So, Chloe, what is the question going to have to be on remand in O'Keefe if we're going to apply the discovery rule? Let's see, Chloe. There you are.
The question would have to be whether she used due diligence to recover the paintings at the time of the theft and after. So.
And why would we want to, why do we need to do that inquiry? That's exactly right. So why do we do that inquiry?
So we can know when the time started to accrue.
Because we're looking for what moment in time? We're trying to figure out what?
When the statute of limitations should start.
Right, which as a factual matter is what moment in time? So those are all legal, those are legal, that you're giving me the legal standard, the legal answer, and that's what we are ultimately going to have to apply, right? And so when does the statute of limitations start according to the discovery rule?
When she notices or should have noticed that the paintings were gone.
Great, when she should have known, not just that they were gone, so just to let's make sure we're precise with it, not when they were gone, but where they were so that she could sue. Because when she discovers that they're gone, she doesn't know who to sue at that particular time. So what we have to find out is whether she used diligence and when she would have known or should have known where the items were. Okay, so we're remanding the case to apply the discovery rule and ask that question. Let me do this. So I'm a big person. I like decision trees. And so let's look at this for a second. And so this is how I think about the discovery rule. Okay. Really, maybe I shouldn't ask the question, did the owner know? But it's really a matter of when the owner knew. Okay, so is there a time in the past when the owner knew? Okay, did the owner know? If the answer to that is yes, they did know, then at that moment that they did know where the thing was, right? So did owner know where thing was? All elements of her cause of action. If the answer to that is yes, they did at some point, then the adverse possession clock starts at the time that the owner knew. Okay, that is pretty straightforward. It gets more complicated, and in fact, these are going to be the cases that we have when the question is, when the answer is no, the owner never knew. Like Georgia O'Keeffe here, never knew up until 1975 where the things were. Okay, so then we ask a different question. Not did she know, but should she have known? Okay, should she have known? And so there's a lot of different potential forks here for the should she have known question. The first is, let's go with this one. Let's assume for a second that Georgia O'Keeffe was super diligent. Every day from 1946 until 1975, she was looking, she reported everywhere, she did everything that she could possibly do in order to find this thing, and she never found it until 1975. If she is diligent, then the clock never starts. Okay? Clock never starts. If, on the other hand, she isn't diligent, but had she been diligent, she would have figured this out. So let's say that had she told Stieglitz, her husband, hey, my paintings are missing. What do you know? And he knew where the things were because maybe he had given them away or sold them or something like that. Well, then she would have discovered where they were at that particular time. She should have known, if she had been diligent, where they were. If that's the factual situation, this is what it's being remanded to determine, should she have known, then the clock starts at the time that the owner should have known. Okay? So here we have, she wasn't diligent, but she should have known, therefore the clock starts when she should have known. Here, she was diligent and never did know, and therefore shouldn't have known, and so the clock never starts. So this middle one suggests that the true owner can always foreclose the clock from starting. And Chloe, how does the true owner stop the clock from starting?
Through due diligence to recover the paintings.
Yeah, so as long as you are exercising your right, then you don't have to worry about losing personal property through adverse possession. As long as you are diligent in your protection of your right, then you don't have to worry. Okay? But if you're not diligent, then you're subject to, oh no, I should have known at this particular time. The tricky space is over here. What if you weren't diligent, as Georgia O'Keeffe probably was not, but even if you had been diligent, you would never have known. Okay, she never would have known this potentially, because paintings or watches or other personal property is of such a nature that it's so easy to hide, so easy to change hands. It is constantly moving potentially. It might be on the other side of the country or the other side of the state or whatever, that you just might be really diligent and never find it. So the question is, and Chloe, I guess I'll ask you, if that's the situation, the owner wasn't diligent, but even if they had been diligent, they wouldn't have found it. Do you think the clock should start against them simply from not being diligent? That's one side. Or do you think the clock should not start because no matter how diligent they were, they shouldn't have known?
I guess that it shouldn't start because it wouldn't have mattered what they did. They wouldn't have been able to know.
Great. So if that is the case, then, you know, does that encourage or does that reward them for, I don't know if reward is the right word. Does that protect them for from their lack of diligence?
Yes.
A little bit. It doesn't wholly protect them because it's possible that their lack of diligence is going to end up over here. They should have known, but it might protect them a little. What do others think about you know, those two choices? If the choices are either we say it never starts, as Chloe has said, it never starts because the answer to the question is they shouldn't have known, or do we say if they're not diligent, then forget them. It starts as soon as they stop being diligent. Hunter, what do you think?
I think it should start as soon as they're not being diligent, because in a sense, it's kind of like they've abandoned their right to the property. Like they're not making an effort to try to find it. So they're not really concerned about it, in my opinion.
And so this is the sort of the opposite perspective, that if we want them to have their rights protected in the end, then they need to do the work of protecting their rights from the beginning.
Yes.
Okay. Others on this question? Start it immediately as soon as they stop being diligent, or give them the benefit of the fact that they never would have found it no matter how diligent they were. Because essentially what you're saying is they should waste their time and energy protecting, you know, searching for something that they never would have found anyway.
I'm kind of like comparing it to like in my head to like sleeping on your rights. Like you're not making any effort to recover your property. So if somebody else has your property, I don't know where I was going with that, but yeah.
Yeah, it's a sleeping on your rights argument, but you know, you're saying you should wake up even if waking up is pointless. Yeah. Ryan, what do you think?
I just think that in terms of protecting the owner of the property against thieves, that it's in the interest to allow that the owner of the property to kind of wake up and realize that it actually was stolen. Like if you have a lot of possessions, it's harder to recognize when your possessions are stolen, especially when you're an artist with a lot of paintings.
And so you're kind of with Chloe on this, that if they aren't going to find it, then we don't need to rush to take it to foreclose their ability to recover things.
Correct. I think it's kind of a waste of their time and money and efforts.
Okay. JC, what do you think?
I'm kind of looking at it like you don't know if you don't try. I guess for the point of our discussion is more like we know that they wouldn't find it, but it's always an off chance that if you are diligent, you might find it, even if it's very unlikely. But I'm going to agree with Hunter on the side of there should be some sort of diligence for continually looking at it, continually asserting the right that that property is still mine. Now, what extent of their acts, I'm not sure on that one.
Yeah, it's a fair point that how are we ever going to prove that they never would have found it? That's a difficult thing to prove. And I just want to note that this case settles, and I think I may have mentioned this on last week as well. This case settles because they're not going to be able to resolve this question, this factual question from a satisfactory proof point. You know, was she diligent? What would she have known? Had she reported something in 1946 or 47? What would she have found out? Who knows, right? That was 27 years ago or something at the time that this suit is unfolding. And so I think that the sort of practical point that how you would ever prove that you would end up in the blue category here, how you would ever prove that is maybe hard to imagine. I will let you guys know, or Abby, you got a thought on this. Go ahead.
I just wanted to know if there was like a standard for diligence or if it's all subjective to the case.
I think it's all subjective to the case. You know, y'all are hearing in torts, I'm sure, about a reasonable what would a reasonable, how would a reasonable person behave? It's the same kind of thing. How does a reasonable person protect their right when we're talking about a specific type of thing? And so back with the watch, you guys talked about, I think you guys talked about the value of the watch, right? The more valuable the thing, then presumably the more diligent you would be expected to be in order to protect the right. Okay, is that answering your question? Okay, so what I was gonna close the loop on with this is that in that blue category, different jurisdictions do different things. Some do, like Chloe suggested, they say, look, if you're not going to find it, then we're not going to punish you. Like the facts were that you wouldn't have found it. And so adverse possession is not a laundering service that gets stuff from person A to person B, without their permission. And therefore we should protect that the true owner from being adversely protected against. Other jurisdictions do the opposite. They do what Hunter suggested, which is they say, look, if you're not being diligent, then forget you. We're not protecting your rights for you. We're going to start this clock as soon as you stop being diligent. And then in this particular case, what we have is sort of the ultimate question, which is, was she diligent? Had she been diligent, when would she have known? Would have been any earlier than 1975? And if so, then we're going to run the adverse possession clock from that particular time. Okay, so I'm going to move to the good faith purchase part of the O'Keefe case in just a second, but I want to open up space. Are there questions on the discovery rule or its application in O'Keefe?
Yeah, can you hear me? Okay. I was just wondering, and maybe you covered this and I missed it, but in terms of diligence, is there sort of a constrained time frame, or do you have to consistently continue to diligently search the entire time that's been lost?
So I think that in a lot of jurisdictions, what they'll say is making a police report, or, in this case, they talk a little bit about, is there some sort of registry for reporting lost art items? I think that what you can do is essentially pass on your diligence to an entity like the police or like a lost art registry to say, that is now me permanently putting the world on notice that I have lost this thing and I would like it returned to me. So I don't think that if we go back to the watch, I don't think that the watch owner really needed to be there every day, for the rest of eternity in order to be diligent. I think, reporting it to the city park might have been a good thing for the watch owner. Just like reporting to the police, if you think something is stolen, is probably a good idea in terms of diligence. And here, if you recognize on the remand, they're saying, we need to find out, was there somewhere she could have reported it at that particular time? Because if you've done that, and it's possible that that's like check the box and you never really have to do physically anything ever again.
Thanks.
Mm-hmm. Other questions on discovery rule? It's tricky. Yeah, JC.
Once the clock starts, nothing will stop it, right? For the discovery rule.
So the court talks a little bit about the changing of hands. If for example, that the item belongs to, the item is being held by Snyder, let's say, and Snyder then sells the paintings to you, and then you sell the painting to someone else, and then and it changes hands a lot. I think it's possible that you might be able to what would be called toll the running of the clock in that instance. But in general, the answer to your question is no. Once it starts, you should sue at that point, because presumably from Snyder, you should be able to trace the item. right? And so even if you sue Snyder, Snyder will say, oh, I sold it to JC. And then you can bring in all the other people. So the general answer is no, the clock does not toll. It just starts running at that point. And unless there's some sort of really compelling reason why it should be tolled, then TOLLED, then it keeps running.
Makes sense.
Anybody else on this? Ready to roll? Okay. So I've mentioned that this is a case that could be about a true owner versus a good faith purchaser. And the truth of the matter is, in this case, we don't really get a lot about the good faith purchase, but I want to introduce this concept to you guys because it's really important in property law in general. And so Snyder might lose on the adverse possession, right? If we can't prove that Georgia O'Keeffe knew or should have known where the item was until 1975, then Snyder is going to lose on the adverse possession question. And so Snyder brings this other point up that, well, maybe Snyder or Frank qualify as good faith purchasers, and therefore good faith purchasers can defeat even the true owner. Okay, and so you know what we're dealing with, if we're tracing the arc of what we've done in the course so far, you know, we've had finders versus site owners, and two simultaneous finders in Pearson v. Post, and finders against bailees in the Armory case, and a lot on finders versus site owners. And here we've been dealing in adverse possession with possessors versus true owners. And with a good faith purchaser, we're also dealing with true owners versus possessors or good faith purchasers, a different version of a possessor. So an adverse possessor might be a possessor versus true owner option, or a good faith purchaser might be a possessor versus true owner option. So I want you to note that it's a different version of the same kind of thing we're talking about with adverse possession, where someone is trying to claim that even though they did not buy the thing from the true owner, they should nonetheless take title superior to the true owner. Okay? Adverse possession, it's because of their possession. Good faith purchase, it's because of their purchase. Okay? And so in this instance, what we're dealing with is two innocent parties. Okay? So let's say this is not, it's not known exactly how the Frank family came into possession of the paintings. Okay? But let's tell a little story. Let's say that Stieglitz, Georgia O'Keeffe's sort of the person who ran the gallery and managed her paintings. Let's say that Stieglitz did have a family relationship with the Frank family, okay? And that Stieglitz, with apparent authority to do so, sold the paintings to the Georgia O'Keeffe paintings to the Frank family, okay? Not gave, but sold the paintings to the Frank family. Okay, the Frank family. What does the Frank family know about Stieglitz in this, in this version of the story? What do they know about Stieglitz and Stieglitz's relationship to Georgia O'Keeffe?
Sorry, I probably that he's her husband and that he sort of acts as her. Well, they think that he kind of acts as her agent, in selling her art.
Yeah, and so when they are purchasing from Georgia O'Keeffe painting from Stieglitz, what do they think? Do they think he has authority to do this, or that he's stolen it and is selling them hot?
Yeah, that he has authority to do it. I think they're.
And so, right, and so we would say that they are essentially innocent parties here, right? They are paying money for a painting to get it from a person who they have every reason to believe has authority to be selling this painting. And then what about Georgia O'Keeffe in this situation? When she gave the paintings or left the paintings with Stieglitz, Did she do anything wrong in that instance?
No.
No, she hasn't done anything wrong either, right? Like, it's perfectly within her rights to hand a painting to her agent or to her gallery or to her husband. That is, she hasn't done anything wrong. And so often with a good faith purchaser versus a true owner, the dispute is between two innocent parties, okay? O'Keefe has innocently given her painting to her agent, and now it's gone. Frank has innocently purchased a painting from an agent with apparent authority to sell, and now the true owner is coming back and claiming it, okay? And so we have this conflict between a true owner and a good faith purchaser, both being innocent parties. Before I go forward, Kimberly, I see your hand. What's up?
How would you know, like, where, for art, how would you know where the line of good faith purchaser is? Because in, like, me looking at it, this person bought 3 O'Keefes for what, adjusted for inflation's around $150,000. Meanwhile, O'Keefe's sell for $150 million. But it, unlike an iPhone or something that has like a very definite purchase price, where if I walk up and say, you want this phone for $10, somebody would say, that's sketchy.
Mm-hmm.
How would you know for something like artwork where that good faith line is?
Great question. And you've hit on the thing that I have skipped over thus far, right? I'm saying the words good faith purchaser, good faith purchaser, good faith purchaser, but we haven't defined how you qualify as a good faith purchaser. And Kimberly's comment alludes to it, right? The word sketchy is a great word when we're thinking about good faith purchaser. If there is something sketchy about the purchase that you are making, then you cannot be a good faith purchaser, okay? And so the two parts of the phrase good faith purchaser are good faith, which is you have no reason to believe there is something amiss, that there is something sketchy with this particular transaction. So it's not like Stieglitz is meeting you in a back alley and saying, don't tell anyone, I'm now selling you this, right? So that's good faith. So there's nothing like sending off alarm bells, because Kimberly, I'll ask you, if that's what happens, right? If Stieglitz says, you know, he's constantly looking around and he's got him like, you know, really kind of hidden underneath a blanket, and he says, listen, don't tell Georgia, but I'm going to sell you these, and just keep it quiet. And then sells it to Frank. Is Frank an innocent party anymore?
Reasonably, no.
Reasonably, no, right? So in the dialogue with Annie, we were trying to establish that what we have is a good faith purchaser and a true owner, and both are innocent parties. No one's really done anything wrong, but we only have one painting, and so we have to determine who gets it. But if there is something sketchy about the transaction, then all of a sudden we feel differently, right? We feel, well, actually, Georgia O'Keeffe is still an innocent party. The true owner is still an innocent party, but the Frank character is no longer purchasing in good faith. And therefore, when we have to choose, we're going to say, you're not a good faith purchaser. It goes back to the true owner. So good faith is one part. The other part is purchase. So I was careful to say that Stieglitz sold the paintings to Frank as opposed to gave the paintings to Frank. So a good faith purchaser must be what's known as a purchaser for value. That means they have to pay the market value of the item in order to qualify as a good faith purchaser. So the iPhone for $10 is a great example. If you, let's say you even buy it from, you know, a store that sells iPhones, but they're charging you only $10, then that doesn't qualify in order to become a good faith purchaser to get the protections of the good faith purchase, because you are not a purchaser for value. Okay. Now, that all of that, hopefully y'all got all that. All of that doesn't really answer your question, Kimberly, which is, in this particular context, how do we know, right? And the answer is not going to be satisfactory, but the answer is we're going to have to look at the particular transaction and say, was there something that should have put Frank on notice that something was up with this, right? So one, if in fact it's off, the price is off by a factor of 1,000, right? Well, then that's probably not going to allow Frank to be a good faith purchaser. Or if there's something off like the back alley scenario that I described. But it's going to be based on the situation at the time that the transaction occurred, okay? Situation at the time that the transaction occurred. And it's not satisfactory because I can't give you like a hard and fast rule on it. But the things that you're going to look at are, what are the circumstances of the transaction and what was the price? And what was the prices in relation to the actual value?
So in this situation, even if we assume like most of us wouldn't know how much an O'Keefe is worth if we just ran across it, the responsibility would be on us to find the market value and make sure we're paying fair price, correct?
If we want to have the protection of being a good faith purchaser, that responsibility would be on us, yes. And so if we fail to do so, we can still buy the painting, but we're not getting the benefits of being a good faith purchaser. So those are the two parts, good faith and purchase. So the question becomes, like, other than this little story that I've told about Stieglitz and O'Keefe, when does this happen, right? When do good faith purchases occur? And I guess let me back up. Well, no, let's go with that. So, Annie, did you pick up from the case when good faith purchases might happen from the case or notes?
Oh, sorry, I am unmuted. I know, well, when Frank sells it to Stieglitz is in 75.
Yeah, so Frank to
I
Snyder.
think.
Yeah.
Oh, sorry. Yeah, to Snyder, sorry. Yeah, I think it's in 75. And
Okay.
that's sort of how he gets put on notice.
Right, and so, but the court talks a little bit about situations in which good faith purchase might be a viable argument. And so if Snyder's going to make it, it has to sort of qualify as one of these kinds of situations. Did you see where they're talking about when someone might be able to qualify for good faith purchase status? Or Josh, did you see that anywhere?
Sorry, still looking.
Or anyone?
Would it be page 182?
Okay. Where on 182, Tierney?
I guess the second paragraph, where it
Yes.
says, our discussion begins with the principle that, generally speaking, if the paintings were stolen, the thief acquired no title and could not transfer good title to others, regardless of their good faith and ignorance of the theft.
Great. So that's a situation in which good faith purchase does not apply, right? So we can say that if there really was a theft, what qualifies as an unlawful taking of possession, if that's what's happened, then good faith purchase is out. Okay, there's no cleansing of that. Okay, but so I'm asking, when might it be? So we know when it isn't. Good faith purchase is not going to follow a theft, but when might good faith purchase happen? You're right in the neighborhood, Tierney. JC, what do you see?
Is it when there's a voidable title?
Yeah, so what does that mean?
As a voidable title, it's kind of like if we have a person who owns a jewelry shop, someone comes and wants to purchase some jewelry, gives some false information to acquire credit for that, and then the jewelry store owner doesn't know it, that he's using false information and doesn't actually have good credit, then that guy has title, the jewelry store intended to sell that item to him, and then he turns around and sells it for full value to someone else. So the person in the middle had a voidable title, and then the good faith purchaser has a valid title.
Great. And so there's two scenarios really where this often comes up. One is this situation where there's some kind of semi-fraudulent behavior that allows someone to come into what appears to be rightful possession of an item. So in JC's example, it's the person that has bad credit that gets, sort of falsely gets good credit. If you look in the note 30 on that page 182, it's giving you a list of these kinds of scenarios, right? Here, where the transferor was deceived as to the identity of the purchaser, or the delivery was in exchange for a bad check, or it was agreed that the transaction was to be a cash sale, so that there was like an agreement that there would be payment at some point later, or the delivery was procured through fraud, punishable as larcenous under the criminal law. So note that fraud is different from theft. Fraud would be tricking someone into giving you possession. So in all four of those scenarios, the person obtains the item fraudulently or wrongfully, but there's no record of that at the time, right? And while they have it, the word is voidable. That means as soon as the fraud is discovered, then in JC's example, the jewelry store can come back and get the item and say, hey, you gave me a bad check or whatever, okay, and get this piece of jewelry back. So it's voidable. But until it has been voided, until the jewelry store does that, then the crook, for a lack of a better descriptor, still has the thing and still seems to have good title to the thing, to the jewelry. And so if they, before it gets voided, go out and sell for full value in a open market, essentially, so nothing that would suggest that this is sketchy. If they do that, then that other purchaser becomes a good faith purchaser, because JC, is that other purchaser an innocent party here?
Yes, as long as nothing's sketchy and they're paying market value.
Great. And so as long as there is nothing sketchy and they're paying market value, they are an innocent party, and therefore they win over to get the item, they win over in this example, the jewelry store. Now I want y'all to note that the jewelry store can still sue this guy for the bad check, okay? What we're talking about here is whether or not the jewelry store can get the jewelry back. And the answer there is no. The good faith purchaser will beat the true owner in that particular example. So one situation in which good faith purchase often comes up is when there is quote unquote voidable title. JC, in that instance, what is the court protecting? By protecting the good faith purchaser over the true owner, what has the property system, what has the legal system protected?
Say, probably just the general market economy of people making transactions and exchanging goods for money.
Great. It is protected transactions. And we will see, and perhaps in contracts you're seeing already, it is very important for there to be some sort of reliability and predictability in transactions. Because if every transaction becomes the possibility for, it being undone because someone was behaving badly, then all of a sudden, all of the relationships, all of the transactions that make up the market economy become vulnerable to, being undone, okay? And so at root, what the good faith purchaser rule is doing is protecting transactions over ownership interests, okay? Protecting transactions over ownership interests. And we would only want to do that in situations where the transaction from the purchaser's standpoint is a normal transaction. We want purchasers to be able to trust normal transactions. Yeah, Ryan.
You said that the voidable title protected against the true owner.
Protects, it has the good faith purchaser defeat the true owner, so it does not protect.
Okay. Okay, I maybe my misunderstanding is coming from when we talked about this in torts, but I thought that the point of it being voidable was that the true owner could void it, and that's not the case.
It is voidable. Yeah. Okay, let me back up. It is voidable, and the true owner can void it. Okay, but if the item has moved on before that voiding happens, then the item is gone from the true owner. The good faith purchaser will beat the true owner. The true owner, even though they lose the item, they can still sue the crook to get the value of the item as damages, but they just can't get the item back. And so is that making sense? So it's voidable, and so it does, I suppose, protect the true owner in some sense, in that they could get damages, but it does not. If they don't void it in time, it does not get them their item back.
That makes sense. Thank you. I appreciate it.
So one situation is voidable title. The other is also, it's this item 2 on that same note on 182. Any entrusting of possession of goods to a merchant who deals in goods of that kind gives him, the merchant, power to transfer all rights of the entrustor to a buyer in the ordinary course of business. And so the other place where this happens, and I'm going to use jewelry store again because this is fairly typical. Let's say I take a watch to a jewelry store to be fixed, and the jewelry store fixes it and puts it up for sale and sells it to someone else. Okay? If that's what happens, the true owner again loses, not so much because there was never any voidable title that the jewelry store had for my watch. Rather, here we're protecting again the market, in that when you go to a jewelry store, sometimes they have watches for sale. There's no reason for someone to walk into a jewelry store and think, oh, this is probably someone else's watch that I'm buying. They have every reason to believe that there's nothing wrong with this transaction, and therefore get the benefits, assuming that they pay full value for the watch. They get the benefits of being a good faith purchaser. So the two situations in which good faith purchase typically applies are when there is voidable title, right? When the seller has voidable title, or when the seller is what's called a merchant. That means they are an individual who has possession of the thing somehow, maybe as a repair, who is in the business of selling this type of thing. Now, if I walked into a jewelry store and they were selling me a TV, then it's a different scenario. Okay, different scenario. And then the other thing that we take is that a good faith purchase does not cleanse a straight theft, where I just go and steal something from someone. Note that voidable title, a bad check, is close to stealing from someone, but it is not the same thing. Okay, so a straight theft will never give you, cannot be cleansed, but these other kinds of situations, good faith purchase might come into play. Okay? Questions? We good? Yeah, Davis.
But this is, so in that situation with the jewelry store, they would still be liable for damages though, correct? Like to repay you for your what? Okay. It made sense. I wanted to double check that one.
Yeah. So always remember that our, when we're dealing with the isolated conflicts, that doesn't mean that there are no other potential avenues for people who lose their stuff, right? They can sue in that example, they sue the jewelry store and say, hey, I gave you my watch to fix it and you sold it to somebody else. You may not be able to get your watch back, but you definitely have a cause of action against the jewelry store for, essentially stealing your watch.
Thank you.
Mm-hmm. Other questions on this, on O'Keefe? We good? With good faith purchase, with discovery rule. So now let's open it up. We got 15 minutes left. So let's open it up to just general questions, review questions from adverse possession or prior. This is your moment. I'm at your service. Yeah, Thomas. Where are you? Tommy.
Hello.
Yeah.
Yeah, when we're answering questions on this exam and any other exam you give us, do you want us to use the IRAC method?
I'm reluctant to dictate what method, I don't want you to feel bound to use any particular method. The IRAC method is great for forcing you to organize something. So that's fine, but it doesn't really matter to me how you do it. But the reason I say it's fine is because it's going to force you to do the things you need to do to provide an answer, which is, identify what rule you're going to need to apply. And then the A is going to be the most important section here. I would note that I would like to see, so you might end up having to do multiple racks, like if there's an adverse possession question and it has an issue that is related to openness and an issue that is related to tacking, right? Well, then you're going to need to do multiples within one answer. So that's one thing to keep in mind. Another thing is I generally like for you to identify weak spots and therefore kind of make the opposing argument as well. And to say, well, they might argue that there is tacking, but the other side is going to say there isn't tacking because there's no privity, et cetera. And so you might even have like a mini IRAC that's running against what your ultimate conclusion is, if that's making sense. As opposed to a brief where, you really want to stick and argue your point and stay on topic. Here, I'm really grading your depth of analysis. That's really what I'm grading. And so the more evidence I have of depth of analysis, the better. Yeah, Julie.
I have a question more for like property for the year, but is there really going to be a time where we're out of the old English, like very dated, kind of arguably a little bit hard to read, a little slow cases? Like, are we going to get more modern with it, or is property just kind of an old thing?
You are stuck here, Julie. You're stuck with the old stuff. I will warn you that what we are going to after next, maybe even maybe even next Wednesday, is going to be, I'm reluctant to say it this way, is going to be even worse than where we've been so far. The cases aren't going to be necessarily old, but the concepts become extremely technical. So that is our next area. But I'm hopeful that you can see that these issues are very, very modern. The rules are, coming from very, very old principles. The second semester, I think, is better in terms of connections to sort of maybe everyday issues. Like we'll do landlord-tenant, and we'll do real estate transactions, and those are sort of more relatable experiences. Our next topic is setting you up to where you could set up wills for people, which is a major area of property practice.
I have a question.
Yes.
Could we go over, could you just explain the differences between the other doctrines for boundary disputes? I guess I want to know, what does acquiescence and estoppel mean again?
Great. So adverse possession is one way in which you could solve a boundary dispute, but these other doctrines are alternatives to adverse possession, because adverse possession can be harsh and difficult. So acquiescence and agreed boundaries are very close to one another, so I'm kind of going to talk about them together. Acquiescence is when, let's say, there is a fence that is, let's say, 18 inches off the property line, one way or the other. Okay, so it's not on the property line, it's off the property line. Well, if that happens and there is a long period of behavior in which the parties seem to act as though that is the property line, and one way in which parties might act that way is who does the upkeep on either side of the fence. So if the party on the left side of the fence or the west side of the fence always upkeeps everything up to the fence line, and the party on the east side of the fence always upkeeps everything, that mows the grass, plants flowers, etc., east up to the fence line, they're behaving as though that is the property line, then that can develop into the property line if the parties, the word is if the parties acquiesce in treating it as the property line. Okay, that's slightly different from agreed boundaries, which is the same basic principle, except that there has been some sort of conversation about it. So here we're looking at, in acquiescence, we're looking at behavior. In agreed boundaries, we're looking at an oral agreement. So maybe the two neighbors got together and said, hey, do you think the fence is on the property line? And they say, yeah, I do. Oh, I do too. Okay, let's agree that that's the property line. Okay, that would be agreed boundaries. Acquiescence is more based on behavior than that kind of meeting of the minds idea. And then estoppel does not require a meeting of the minds. It requires a representation by one party, like, is this where the property line is? Yes, that's where the property line is. That's a representation by one party that is relied on by the other party. Okay, and so you told me that's where the property line is, so I'm going to put my fence there. Okay, well, you can't subsequently, if Tierney, if you tell me that's where the property line is and then I build my fence there, you cannot come back later and say, actually, I lied, the property line is somewhere else. Okay, you are stopped from changing your position when I have relied upon your representation. So estoppel is all about there being a representation that is relied upon, and that I will be damaged if you reverse what you have said or what you have represented. You good? That work? Okay. Other folks? Or is everybody else beaten down by property like Julie?
I think property is great. It's very nice. I was just wondering about the cases, but I love property.
I can hear it in your voice. Property was my least favorite class as a first-year law student. When I applied for a job to teach at a law school, I said that I would be very qualified to teach contracts. The University of Memphis hired somebody else to teach contracts, but then the person who taught property left the University of Memphis, and so they came to Plan B, and they said, he probably needs a job still. So they said, well, what do you think about property? And I said, well, I don't have any experience with property other than, buying my house. And they said, well, we think you can do it. And so I've been teaching property ever since. I like to say that it was my least favorite course because I didn't have myself as my teacher. Although Professor Brazier is pretty awesome too. I didn't have him either. Any other questions?
Yeah, Professor, do you want to stay on and help us with our contracts midterm in 20 minutes?
Oh, y'all have a contracts midterm in 20
Yeah,
minutes?
you said you wanted to teach contracts. So, I mean, we can give you.
That was a long time ago. You do not want me helping with your contracts midterm. Are you guys in the Gibson contracts class?
Yeah.
I really do want to, but I have a class, so I can't. Well, I'm going to let y'all go then. If y'all have a midterm, then goodness, go do it. All right, good luck. Do good.
Professor Keel,
Yes.
I just want to say I like IP. I like intellectual property law, which is kind of like this class. We talked about it with the Vanna White case and whatever, but that interests me a lot. So that's I guess that's kind of my roundabout way of asking. But I was not saying your class is boring at all.
We're not gonna unfortunately do any IP beyond Vanna White, and that area is much, obviously, it's just much more alive. Patents and I think patents especially, but those are really statutory classes, and in the first year you just don't encounter statutory classes. They're harder to teach the sort of legal analysis with statutes, and so the common law is usually just the better way to do that.
Right.
But
So,
we have our IP classes, for next year and the year after.
Yeah, I started reading next week's case, and that one's also kind of old, and I was like, what is going on? But anyways, thank you. I appreciate it.
Good luck on the test.
Thank you.